up, everybody? Back here with another horrible story. Unfortunately, it's just what it is. Another horrible story. I don't know what's going on in our world to the point that everybody's messing up. What is it really that's making everyone mess up? I don't know. Let's just get into it. There's no need for talking. It speaks for itself. It's a horrible story. Horrible for everyone. And you'll see this in the proceedings. This is horrible. This is a hard one to watch, man. So I'm telling you from now, you go ahead and take that proceed with caution. This is not meant for, it's not meant for children. This is not meant for, yeah, it's just, this is horrible. This is the only way I can put it. That's it.
661581. So before I begin the presentation, I believe that is the intent of both parties to stipulate to those reports and to make those reports part and parcel of case number 661581.
Okay, there was, the prior docket was indeed titled CR 21658-361, and the record does reflect there was that stipulation. Does the defense have anything to say or agree or disagree on that?
Your Honor, we do stipulate to the competency and sanity as we have previously done in the prior case.
Okay, so the conclusion of the reports was that he was competent, he was sane, and was able to go forward with trial. Therefore, he's able to go forward with the plea. All right, and what is the plea offer?
Thank you, Your Honor. Good afternoon. This is a 4-count indictment. We have had full discussions and disclosure, and all evidence that the state of Ohio intended on using in this case has been transferred to the defense.
Thank you.
It is my understanding that today this defendant is prepared to withdraw his not guilty plea and enter a plea of guilt as outlined. The state is going to respectfully request that this court, with regards to count 1, delete the victim under 13 murder specification. So count 1 is aggravated murder in violation of Ohio Revised Code 2903.001C. It carries with it a potential penalty of life without parole, life at the eligibility of parole after serving 30 full years, life with the eligibility of parole after 25 years, and life with the eligibility of parole after 20 years. And there is a fine of up to $25,000. With regards to count 2, we are going to respectfully ask this court to amend count 2 to reflect the kidnapping statute in violation of Ohio Revised Code 2905.01A3. And it reads, Your Honor, that no person by force, threat, or deception, or in case of a victim under the age of 13 or mentally incompetent by any means shall remove another from a place where the other person is found or restrain them of their liberty for the purpose of A3, to terrorize or inflict serious physical harm on the victim. Since this is an amendment, it is my further understanding that at the time of the plea, the defense will be waiving defects in notice and service in this indictment process. The penalties for a felony of the first degree, Your Honor, carry a potential penalty of 3, 4, 5, 6, 7, 8, 9, 10, 11 years, and a fine of up to $20,000 at this court's discretion. In addition, it makes count 2 and S1 makes it eligible for the rated totes, which means that it's eligible for an indefinite sentence. So whatever sentence that is given on count 2, the sentence then, they take 1/2 of that, and that would become the indefinite sentence in count 2. And with regards to count 3, it is endangering children in violation of Ohio Revised Code 2919.22B2. It is a felony of the second degree, Your Honor, and it carries with it a potential penalty of 2, 3, 4, 5, 6, 7, 8 years, and a fine of $15,000 at this court's discretion. Your Honor, in addition, the parties are coming before this court and are asking that you impose an agreed amount sentence to total life with the eligibility of parole after 45 years. And we understand that with regards to count 1, it would be life imprisonment with parole eligibility after 30 full years, an indefinite prison term on count 2 with a minimum term of 8 years. With regards to count 3, an indefinite prison term with a minimum prison term of 7 years. Counts 2 and 3 are an aggregate of Senate Bill 201, which is the Reagan totes, which would be a sentence of 15 to 19 years in prison. Each count is to be served consecutively for an aggregate prison of life in prison with the eligibility of parole after 45 years. In addition, Your Honor, the state of Ohio would ask that you respectfully dismiss count 4 of this indictment. There have been no promises, no threats, and no inducements made to this defendant to withdraw his not guilty plea and enter a plea of guilt as outlined. There is a factual basis for the same, Your Honor. Excuse me, and Your Honor, in addition, counts 2 and 3 are non-allied offenses of similar import.
So the proposed agreement here is life without parole, 30 at plus the 15 from counts 2 and 3, the indefinite sentences that are aggregated, in addition to potential Reagan totes. So he's getting, what would you put the total at? Life without parole plus?
It's 45 years.
45,
If you add
okay.
the Reagan totes, would be an indefinite of 4. So,
Okay, so life without parole, the 30 and 15 is 45 plus 4 additional possibility
roll
of
that
Reagan
one.
totes would apply for future bad behavior.
You just
Correct.
roll that one, so.
Okay. All right, and we have a notice to enroll for violent offender issue.
yes, Your Honor, pursuant to Sierra's law, it is, I believe, 201. I don't have the form in front of me. By pleading guilty to aggravated murder, it is a notice that has to be signed by the defendant, which gives him the duties to enroll as a violent offender upon the...
You don't need a copy. Just give it the original. So she can refer to it. Then we're going to hand it to the defense anyhow.
Facts.
Thank
That's the
you.
facts, bro.
Notice of duties to enroll as a violent offender in violation of Ohio Revised Code 2903.41, which gives all the qualifying factors that once he's released after serving his sentence and for a period, which I believe is 10 years, that he has to register in the county as a violent offender.
Okay, and the consequences of failure to do so?
And the failure to do so, Your Honor, would cause an indictment with regards to failing to register, and that would be a felony of the 5th degree.
Which would carry what type?
Penalty of 6 to 12 months and a fine of up to $2,500.
Okay, so that would take place, this registration and mandatory registration for that period after and if he lives through prison and is released.
Correct,
If he fails to do so, he'd go to prison.
correct,
Again, potentially, and if he's indicted and convicted under that failure to register as a violent offender.
correct.
Okay. So as to time served, is there any, do we have an agreement that he's been in 960 days since March 25th, 2021?
Yes, Your Honor.
Yes, Your Honor.
Okay. All right, hand that please to the defense so they can handle that first, then we'll go through their soliloquy regarding the charges and the negotiations.
What is he smiling about? That's shit I don't get. Was his dad nuts? I can't explain it. Having a good old time, ain't they?
Counsel?
Yes, Your Honor. Executed in open court, we, just for the record, we did in fact advise our client of his violent offender database and his requirements for registering in that database once released from prison. He's executed this form in our presence. We've explained it to him again in open court as well. And we have this for the record, Your Honor, signed and dated by Mr. Ponomarenko in open court on today's date.
Thank you.
Thank you. May I approach the bailiff?
Yeah, the bailiff will take it. Now, Mr. Guy, the next question I'm going to ask the defense is, if you form an opinion of yourself as a defendant, is he in a position to make a knowing, intelligent, voluntary plea for your dealings with him? And if you'd outline what you have done to advise him, what you and your team have done to represent him, so the record will reflect that a future reader of this record won't know.
Yes, Your Honor. May the record reflect, may it please the court, that prior to coming into court this afternoon, as recently as yesterday and again today, we've actually gone over the amended count 2 with our client, as well as all the counts which he will be pleading guilty to. It is our understanding, and pursuant to our contact with our client, that he will be entering into this plea knowingly, intelligently, and voluntarily so. We've explained to him that count 2 has been amended with the court's permission, and that we will waive any defects and notice requirements pursuant to the statute.
So,
that we can
so
continue-
for the record, it's clear, it's an aggravated murder, but it's being changed or reduced to a kidnapping, reduced in the sense that it's a lower level
Yes.
offense. And that's part of the plea bargain. That doesn't require a return to the grand jury if you waive it. It would require if you didn't waive it.
Absolutely, and we've explained that to Mr. Ponomarenko prior to coming into court this afternoon, as well as recently as yesterday. So it is our position here that in our communication with him, he will be entering into this plea at the appropriate time and as addressed by his court to the amended count 2 as well as count 1 and count 3 as outlined by the prosecutor this afternoon.
Well, I appreciate it, and amuse me here for a moment that when you say our, I know what you mean by our, but for the record, you're talking about your team.
My team, to my right is Chris Julian, Brent Carroll, and Mary Jo Tiffany. We've all been in his presence, advised him, and and there's no threats or promises that's been made other than what's already been outlined on the record. And we believe that he will be entering into this plea knowingly, intelligently, and voluntarily so.
In these past 32 months since this case has been pending, has your team had frequent and numerous
I agree.
and lengthy contact with the defendant?
Yes, we have. And for the record, we were not the original attorneys on this case. We've been with him for the majority of that time, for about 2 years and 3 months, to be exact. And we have had numerous conversations with both Mr. Ponomarenko and his family. We have consulted experts in this case. We have gone through all the discovery in its entirety. And for the record, I don't believe this was brought up, but there is a serious mental illness claim that we are withdrawing as part of this plea as well.
The so-called SMI.
Yes.
And SMI, and the SMI required examinations by several psychiatrists.
Yes, it does, Your Honor. We've actually gone through several different doctors in that respect. But at this time, we filed a notice back in February of this year that we were going forward with the SMI claim. But pursuant to these plea negotiations, we are withdrawing that at this time. Our client is aware of that. And the plea, as outlined, is actually in a position where the SMI statute would not apply, and it's actually to his benefit for that matter.
Well, I understand, but explain that for the record, what you mean. Now,
For the record, if a SMI claim were to go forward, if we were to have a hearing on this matter, and the court would have to listen to the evidence asserted, it would be our burden to prove that he does have a serious mental illness. We understand that. The court appointed a doctor in that respect to examine Mr. Ponomarenko. The defense also had their own retained doctor with respect to the SMI claim, and the state also had a doctor with respect to the SMI claim. We are foregoing that hearing. The result of that hearing, if we were to prevail in a serious mental illness hearing,
if you were to prevail,
if we were
yes.
to prevail, the only
What would be the benefit of that win, so to speak, or prevailing?
the capital offense would then be off the table if we were to prevail at that hearing, and the only ultimate sentence would be that Mr. Ponomarenko would serve life without parole.
And whatever other counts he was
Yes.
convicted of at then.
Yes.
So
So
you're
for
getting the
those
benefit,
reasons-
in essence, you're getting the benefit of the SMI hearing is if you won, if there's a plea without a death penalty inclusion.
And actually, the parole eligibility is an agreed 45 years, so it's actually less than life without parole. Yes.
Okay.
And he understands that. With that said, Your Honor, that is our understanding. We believe that he will be addressed in the court at the appropriate time pursuant to Rule 11, and we would just defer at this time to the court. Thank you.
Okay. All right. Mr. Ponomarenko, let me speak with you, sir. Now, you are the defendant in the case. All
Alrighty.
issues now are really decided by you. You can receive advice from counsel, a good set of counsel, no doubt, but you have to make the final decision as to a plea. You're the one who will be serving a life sentence. You understand? Okay, you have to answer yes or no, just like a
Yes,
court
sir.
report, but she can't do head shakes because it's hard to tell which way somebody's shaking their head sometimes. So, tell me about yourself. How old are you, sir?
34,
And how far did you go in school?
graduated,
From where?
Parma
What year was that?
O.H.
Parma High School and any other additional school or training?
No, sir.
Okay, what type of work have you had in the past?
Welding, factories, tow motors, cranes, ironwork.
Okay. And when's the last time you worked and what type of work was it? What year was that?
I don't know.
Well, what was the job, the last job, if you recall?
That was, I don't know.
Well, tell me any job that you've had.
How well like
What'd you do there?
a welder?
Okay, were you trained or were you trained on the job? How did you learn to weld?
Trained on the job.
And what type of welding did you do?
Big welding and stick welding.
Okay, so you were, and what types of objects or machinery did you weld?
I didn't weld machinery, I welded galvanized sheet metal.
Okay, and was it to a spec, or was it different orders, different specs, or was it the same?
Mainly the same.
Okay. And if you had other jobs besides the welding at that factory?
Have I had other jobs?
Yeah.
Yeah.
Okay. What kind of work did you do there?
I don't know, I've been job out my whole life. I never really had a steady job, to be honest with you.
Well, pick one that you like.
I don't like working.
Well, pick another one, anyone. You didn't have to like it then.
I'm a stay-at-home dad, that was my job. That was my main job, I was a stay-at-home father.
Okay. How'd you do when you were in
That's the
school?
sad part.
In high school at Parma?
When I applied myself, I got good grades.
I
When
do
didn't try, I
believe
got F's.
Love these children. I
Now,
really
have
do.
you been able to understand what we've been talking about here so far? It's very important
Drugs is
to your
fucking
future
bad.
here, what we're talking about, obviously, right?
No, I'm just going through a lot, sir.
Okay. Are you under any medication today that would affect your ability to think clearly?
I'm on medication, but it doesn't affect my ability to think.
Okay. Are you thinking clearly?
No? Or yes, I am.
Okay.
Sorry.
I want to make sure that you stop the court if there's anything that we talk about that you don't
No, I'm
understand, okay? And you can ask counsel questions or the court questions.
I'm all right, I'm
anything you
good.
want. Okay. Now, you have an absolute right to go to trial. They have offered you a sentence here, and you heard us talk about it, right? And you talked about it with your attorneys already before today, I presume, right?
Yes, sir.
They're offering you a sentence without the death penalty specification, and that would require a life sentence, and in other sentences we'll talk about. So you have to hear very closely, and if you have any questions, you talk to me and ask your question, or I'll talk to your attorney and ask your question, okay? So you have a right to go to trial. Nobody can force you to plead guilty here today. You go to trial, and at trial you can confront the witnesses against you through counsel. So the state would have the burden of proof. They are required to put on witnesses. They are required in a trial to prove your guilt and prove it beyond a reasonable doubt unanimously to a jury of 12. Or a judge if you'd waive that jury, or a panel of judges. In a capital case, it would be 3 separate judges. You understand it?
Yes, sir.
At trial, you could put on your own defense also. You have the ability to compel witnesses' appearance by subpoena. If someone refused to appear for whatever reason, would become involuntarily. If you issued a subpoena, the court would order the deputies, sheriffs to go out, find that person, arrest them, and bring them and transport them and deposit them on a witness stand to testify. They would have to testify. You understand? It's a powerful tool in a defense. Okay. You could you could ask them their questions and present your evidence in that way. You could also testify at the trial. You could take the stand and testify, or you could choose not to testify. If you choose not to testify, no one could comment upon it in violation of your Fifth Amendment right not to incriminate yourself. You understand?
Yes, sir.
You get the state has a burden of proof. They have to present evidence. They have to present evidence so credible that a jury would believe it unanimously to a jury of 12 and find you had violated the particular statutes and every element of every statute that you could be convicted of. So I'll tell you about the statutes, and the content here, but it would take every bit of it and every element to be before you could be convicted. You understand?
Yes, sir.
So if you waive that right to trial and you plead guilty, you are taking responsibility for the actions to which you're charged. You understand that?
Yes, sir.
And you're waiving any future claim of not being guilty, obviously, to what you plead guilty to. You understand? It may require fines if you have abilities to pay and in other court costs and fees. You understand that? Okay. And with each one of these, we'll cover what the fines may be. If you have any questions about the plea process, if you have any questions about your rights to a trial, I want to make sure you know what you're doing.
No, sir.
Okay. All right, in count one, you were charged in this case in docket 661-581 that on March 25th, 2021, you did purposely cause the death of child initials JP. Are we going to continue with the initial and the date of birth, or should we name that child for the record, for the parties?
We usually just keep the initial child, but the name is Jax Ponomareko.
All right, we'll keep the initials, but the record will reflect the name of the child so that there's no question to whom the defendant is pleading to kill in an aggravated murder offense. Okay, so you're charged with purposely causing the death of JP, date of birth July 21st, 2015, who was under the age of 13, under the age of 13 at the time of the commission of the offense. We covered his date of birth, it was July 21st, 15, so he would have been going on 6 years old. He was just under 6 years old by a few months. All right. You understand that charge, and you understand that the penalty will be, as agreed, life imprisonment, how should we phrase it? Life imprisonment and with parole eligibility
With parole
after.
after 30 years.
Goof, so that change.
Now there are,
How can
so
you
he
use
understands that
something-
there are 4 specific
Excuse me.
potential penalties. One is simply life imprisonment without parole. One is after serving 20 years of imprisonment. One is life imprisonment with parole eligibility after serving 25 full years of imprisonment. And finally, life imprisonment with parole eligibility after serving 30 full years of imprisonment, and a fine up to $25,000. And the option that the state is giving by agreement would be life imprisonment without parole eligibility after serving 30 full years of imprisonment. The option with the highest number of years. You
You
understand
ready
that?
for it?
Yes, sir.
Okay. Is there a specification here?
Get ready.
No, Your Honor, specification.
Okay, the specification is out. There's
Is
no
deleted.
weapon or any other
No.
specification. Okay. There isn't in my indictment. I just want to be sure. I'm not missing. Okay. And your plea, sir, is guilty or not guilty, that charge?
I'm only saying this.
No, I don't want, I can't take speeches, you understand? All I can take is you have the option of guilty or not guilty. Those are your options. I don't want motivation.
I don't give a fuck what you want. I'm
Okay.
telling you how I fucking feel. I'm pleading
Now
guilty.
drop, okay.
Sorry, sir. I'm pissed off.
I will accept the apology, but end the profanity, all right?
I don't care, bro. I'm getting 45 years. I don't fuck this shit, bro. I don't give a fuck.
Okay.
Nah, I don't care. My son's
We'll
dad.
give him a minute to
I
calm
did.
down, and we'll proceed.
No, you're not. I'm sorry. I'm pissed off. I get 45 years. How the fuck do you want me to feel?
Hey,
I'm
I
saying,
don't,
okay. Fuck that shit. Run this shit, man. Get this shit over with so I can go drink my fucking coffee.
All right, I want the profanity dropped, and we'll suspend the hearing, and we'll let him calm down and come back in if he wants to
No,
come
I
back
don't
in.
want to. I want to get this over with.
All right,
Sir.
then please, act in a good fashion, okay? All right, now we'll go to count 2, which is now being amended by agreement of parties from aggravated murder, violation 2903.01A. With, in there, he was being accused of purposely with prior calculation designed to cause the death of that child JP of that 2015 birthday, with a victim under age 13 murder specification, which was make this was a death penalty eligible count, and reducing it to a kidnapping, reducing in the sense that it is still a felony. Is that felony second degree? Count 2?
First degree,
First degree, okay, it's 3, I'm sorry. All right,
A3.
all right, now let's go with the language.
Does
What the
anyone
state, I don't
else-
have it in the indictment, I
I
don't think
feel
it's
like
been
I'm
amended.
Yes,
crying
I'll
right
So
rewind.
specify it so he understands it, please.
Sure, that on or about March 25th, 2021, here in Cuyahoga County, this defendant removed from the place where the other person is found or restrained the liberty of JP, date of birth 7/21/2015, to A3, to terrorize or to inflict serious physical harm on the victim.
Okay, and the potential penalties for that?
The potential penalty, Your Honor, for a felony of the first degree carries with it a potential penalty of 3, 4, 5, 6, 7, 8, 9, 10, 11 years in prison and a fine of up to $20,000 at this court's discretion.
And what will the penalty be by the agreement between the parties that you're proposing?
With regards to count 2, 8 years, Your Honor.
Okay. And the potential fine?
The minimum term is 8 years, the potential is the indefinite 12 years.
But there's an agreement to 8.
To 8.
Okay. That'll be consecutive to the other.
To count 3, which is an F2.
And the fine potential for kidnapping under 2905?
$20,000, Your Honor, at this court's discretion.
All right. All right, sir, Mr. Ponomareko, did you understand that proposed plea to count 2?
Yes, sir.
Amended from aggravated murder to kidnapping. You understand?
Yes, sir.
Any questions about it?
No, sir.
How you plead guilty or not guilty?
Guilty, sir.
All right, the court will make a finding also on that one in a moment. All right, now we'll go to count 3, endangering children. The defendant is charged with violating revised code number 2919.22B2, that on that same date, March 25th, 2021, you did to JP, child born July 21st, 2015, child under 18 years of age.
What?
Did recklessly torture or cruelly abuse the child. And furthermore, that violation resulted in serious physical harm to that child, JP, of that 2015 birthday. All in violation of 2919.22B2. This felony of the second degree carrying anywhere from 2 to 8 years in prison and a $15,000 fine. How sir do you plead to that crime
I'm
of
sorry, I'm
endangering
seeing
children?
this for the first time as well. I'm really hoping I didn't just hear what I think I heard.
Guilty, sir.
All right, thank you. Count 4, pursuant to the agreement of parties, and this plea is Nolly, the endangering children. Okay. So we have pleas to aggravated murder, count 1, kidnapping, count 2, and endangering children. Now,
With regards to count 1, it's never articulated. Your Honor. Guilty?
Okay, I thought we did. But, well, it's all right, we'll go over it one more time. If somebody's right, somebody's wrong, it doesn't matter. All right. The how, sir, do you plead?
Guilty, sir.
Okay. Just hold on one second. How, sir, do you plead to the count one, just to be sure, for the record and note?
Guilty, sir.
Okay. Just let me finish the sentence. To violating revised code number 2903.01, subsection C, on March 25th, 2021, purposely causing the death of J.P. child born July 21st, 2015, who was under the age of 13 years at the time of the commission of offense.
Guilty, sir.
All right. I think you pled already, but just to be sure for the record. All right. C, no cause not to accept these. See no evidence that he isn't of sound mind, capable of making the plea. The court accepts him. I accept it based on the reports I've reviewed from the teams of psychiatrists who moved from the initial evaluation of competency and sanity through the SMI psychiatrists, who are obviously reaching the same conclusion that he is capable of, and from my own observations and observations of counsel, he is capable of making these decisions that he has made. Now, we have
Look at that little pop.
given him the violent offender spec or registration. Did I receive that back? Okay,
Yes, for the record, Your Honor, I
Oh, here, you did, okay.
Let's say that on the record, and if I didn't say this earlier, we would object to the Reagan-Tokes position. And
Well, I
renew
am
that-
going over Reagan-Tokes, but I will.
We will renew that as well at the sentence. At the court.
We will, okay. I want to get this final predator received and put on the record that the duties to enroll as a violent offender under Ohio Revised Code number 2903.41 of Matthew Ponomareko, with his Social Security ending in 401 noted, has been given him a copy. He is required to report if and when he is released from prison within 3 days to the local sheriff to where he is residing, staying, or working. Provide all the required biographical information, fingerprints, palm prints, photographs, and to re-enroll annually and to update as described and required, and to re-enroll with this information within 10 days of the anniversary of the calendar date which you initially enrolled after being released from prison. You are required to comply with all these requirements for a period of 10 years upon release from prison. Your first report is to be to the sheriff's office in this Justice Center building on West 3rd, 1215 West 3rd Street. I see it's been signed, dated today, and I will certify that I have specifically informed the offender of his duties. It's so signed at this time, make it part of the file. All right, the court, as noted early, with the count one, defendant is sentenced to life imprisonment with parole eligibility for 30 years of imprisonment. He will be so sentenced, and he will be sentenced in the kidnapping charge in count two with the penalty of 8 years, and a fine up to $20,000. And the endangering children charge in count 3, a felony of the second degree for up to 8 years. I'm sorry, I misstated the kidnapping. The kidnapping is a felony 1 up to 3 to 11 years. But 8 years is the agreed sentence. In count 3, the agreed sentence is 7 years. That further, that the kidnapping and endangering children charges are what is known as Reagan Tokes, R-E-A-G-A-N, Tokes, T-O-K-E-S offenses. And according to Senate Bill 201, as codified, the offenses carry a maximum term which is calculated as being a minimum of the most serious felony plus 50%. In this case, it would be, of the total of 15, would be 4 years additional. It is a rebuttable presumption that the defendant shall be released at the expiration of the minimum term of those, but the Ohio Department of Rehabilitation may rebut that presumption if, at a hearing, makes specific determinations about the offender's conduct while confined, and the offender's threat to society, the offender's restrictive housing, and the offender's security classification. If that ODRC, the Ohio Department of Rehabilitation and Correction, makes the specific determination and rebuts an offender's presumption of release, the offender can be incarcerated after the expiration of the minimum terms. ODRC may make then specific determinations more than once. So in this particular case, at the end of 15, at the life imprisonment and the end of 15, the life imprisonment at 30, parole plus 15 at 45, you theoretically, if you have misbehaved in prison to the point where a hearing is held and specific determinations are made regarding your conduct and you violate the threshold described of bad conduct, you could be sentenced to an additional 4 years. So the 15 aspect, which is consecutive to the life imprisonment 30, would become 19. So you would face up to a total then, that it's 45 years of sentence, but if you misbehave in prison or commit crimes or commit the conduct that would constitute an offense in their eyes, it could be 49 years beyond your life sentence. So as of now, at this point, your sentence will be life in prison with parole eligibility after 45 years, with that understanding that Reagan Tokes could extend it. You will also be placed mandatorily on post-release control, otherwise informally known as parole. The parole period for aggravated murder, I believe itself, is 5 years minimum. Is that correct? Is that changed of late?
I think that's normally what the term is.
All right. And in addition, you could be placed at the same time for a concurrent parole of a mandatory 2 to 5 years on count 2 for the kidnapping, and a concurrent mandatory time of 1.5 to 3 years parole. They'd be redundant in the sense that you're on 3 paroles, but you're for 3 counts, but you're actually on 1 parole for 3 counts. You must be sentenced to parole on 3 counts, but in actuality, as a merger, it's 1 parole. But a violation of parole after release can result in up to 50% increase, a return to prison with a 50% increase in essence of the time you have already done. So for if it was a 10-year sentence, the parole could create a 5-year parole violation situation. We'd go back for 5 more. And it could go on indefinitely. It could go on forever. There's no end to it. So if someone's out on parole, they're violated, they're sent back to prison for 5 more, they're re-paroled, they have parole again, they could go back if they violate parole again for an additional up to half that sentence. So it's a law created to encourage good behavior and lawful behavior after release from prison, and still gives the state of Ohio ability to monitor a defendant on parole in case their behavior becomes dangerous to the public safety, and return them back to the institution where they couldn't harm the unsuspecting or endangered public. So you understand the purposes of it. The court advises you because it theoretically and hopefully would encourage good behavior while you're in prison, if only to understand that there is a consequence for bad behavior or unlawful behavior or dangerous or violent behavior while you're in prison. You will also, as a violent offender, be enrolled in the violent offender database. You understand that will require the form that you filled out and the requirements of the notice that you were given, and that should you ever be paroled and released from prison and you move to any county in this country, you must be registered. And should you violate, that county and state would be known, and it could require a separate indictment for a violation of a felony of the 5th degree. It could carry up to an additional year in prison just for the violent offender issue, either violating a new law or failing to register. We've covered that it will require your photographs, addresses, any vehicles, registrations. That sheriff will note any scars, tattoos, and you will be required to not only provide fingerprints and DNA, but a photograph. Your DNA will hereby be ordered into the database, the national database, so that should any crime occur where there's DNA evidence in the future or in the past, that you match a suspect in that event, the law enforcement agency investigating would be able to match you from that DNA database to that crime potentially, and gather that circumstantial evidence as to the perpetrator, if indeed it's applicable. All right, what else do we need to cover before we go to the victims and anyone who wants to speak on behalf of the defendant and the defendant?
Your Honor, I think the only thing that you missed was citizenship.
Is what?
Citizenship.
Okay.
Is he a U.S. citizen? You asked all the other.
All I can do. I'm gonna make you famous.
All right, counsel, come up to the side bar and educate me as to what you mean on that issue, what I've missed.
The judge, this is a very interesting predicament here. The one question you generally ask somebody at the beginning.
This dude's the biggest shit I ever seen, man. You get high on meth. Yeah, she did, Tommy. She totally did. You whack out and go ahead and bat out your kid. Smiles. I can't call that. I can't call that. Can't say it's nervousness. king. Everybody reacts differently, right? Nah, me, bruh. I just don't took care of my own shit.
All right. From the defense,
If I
now, is
went
there any
that
issue regarding citizenship of the defense?
Any.
If there's an issue regarding citizenship, I have to go into
Okay.
some other notifications. Was the defendant born in the United States?
Yes, he is. He's a United States citizen, Your Honor. There's no issues there.
All right. We all in agreement that he was born here. Has he ever had any allegations of foreign birth or?
No, not at all.
Okay.
And
Is there any doubt from law enforcement that he's a U.S. citizen, anything to indicate he's not?
No.
All right, well, then if there's no disagreement, we won't go any U.S. citizen advice. Okay. Now we'll hear from the other individuals who've been hurt and harmed and affected, no doubt dramatically in these events. So the law requires and requires the court to and requires that we hear and we want to hear from the victims first, and anybody who wants to speak on behalf of this child who was murdered in this fashion can do so. And I ask that individual to address only me, the court. I don't allow soliloquies between the parties or the defendants, okay? So if the victim, witness, or someone would accompany the first person who wants to speak to the podium, I'd appreciate it. You can go, ma'am, you can go out of order or have someone else speak for you, or wait a moment till you feel better. Have someone else speak with you. Why don't we do it that way?
She's indicated, her name is Samantha Cherney. She's the mother of Jax Ponomarenko. She had written to speak to you, but she would like you to read it to yourself, and she does not want to be in the courtroom.
Well, I'd be happy to read it, but I have to put it in the record at some point whenever I'm reading. I can put it in publicly or privately.
Privately, I would ask.
If there's no objection, I'll do that. Okay. All right. You want me to start
I'll
with
bring
that?
it up to you as soon as we're done.
All right.
The second speaker is...
If she changes her mind in the meantime, she's welcome to
Okay,
come in.
that's fine. The second speaker is Jamie Lopez, the aunt of Jax Ponomarenko. And just so you know, Judge, this was Jax Ponomarenko prior to his death.
All right, we'll take, all right, we're going to take a break. Deputy, take him into the holding cell, please.
Matthew, I love you. I love you, son. Fuck the free world! 313! Fuck the free world!
It's okay, Matt.
Fuck everybody.
All right. All right, we're still in session here now, so I don't want any statements. Everybody take a seat.
For that, man.
Let's restore order here.
My apologies to the family. No disrespect.
All right, let's please, I want to have everybody take a seat, including the back on the plaintiff's side, or step out, whatever they want to do. But I want deputies in the hallway there too, if we've got parties out there. All right, let's take 10 minutes here. So let's just talk to each other, talk to one another, that we've got to get through this, and I want to be able to hear everybody. So it's not going to help the matter if we get so emotional that we can't hear one another, okay? So I want to give everybody a chance to speak clearly, in a relaxed fashion. I don't want them rushed. I want everybody to be heard. We're going to ask the defendant, I'm going to have the deputies talk to him for a little while, see if he calms down.
Your Honor, can we approach?
Yes.
Dan DeRose with 19 News.
The attorney. So,
The attorneys are going to approach
Pipe down, Dane.
on this. You just saw an outburst by Matthew Ponomarenko.
but I advise everybody now that there can't be any exchanges between the plaintiff side, defendant side. If there are, and whoever institutes any conversations will be removed from the courthouse immediately. Okay? That's all. I gotta keep it calm, and that's all I do. I just have the deputies carry him out, put him outside the door, and he can't come in back in the building. Okay? For the rest of the day. So avoid that. Just take a couple minutes and calm down. Okay? Let's give a 15-minute. Let's make it a 15-minute break. We'll come back at 22. That gives anybody who wants to get a fresh air. They can take the elevator down and walk outside, cool off a little bit. It's nice and cool. That'll help us get some fresh air and come in. Okay? 15 minutes will be so. Thanks.
As you just heard, the judge is ordering a 15-minute recess here at
It's really a shame, and I really apologize to the family. I am not trying to exacerbate the pain of what's going on here at all. The shit this dude's saying is just like, he did explode. Yeah.
Jax Ponomarenko was about to come up and give her victim impact statement. You heard that the mother had planned to speak, but she was just too emotional, so she withdrew her right to speak. The letter that she was going to read to the court, she asked for the judge to read that to himself and put it on the record privately. That's something that is done. I've also seen in the past, you don't have to have the defendant in the room for a victim impact statement. In fact, I've seen in the past where defendants have asked to be removed during victim impact. That kind of takes the sting away from some of those family members who wants to speak. But the judge would be able to, I believe, allow that to happen because the victim impact statements are really for the judge, are really words for the judge to hear and whether or not to give him harsher sentence, the sentence that's been agreed upon. It's to let the judge know how their life has been impacted by this crime. The judge was also worried about defendants on both sides of the room. You heard Ponomarenko's father, as they were wheeling him out of the courtroom, say, "I love you, son." So there are clearly family members on both sides of this in the courtroom. And just as that explosion was happening, and then he tried to say, I'm okay, I'm okay. We'd already heard quite a bit of language out of Matthew Ponomarenko, using the F-bomb towards the judge, telling he doesn't blanking care what the judge thinks. That was almost enough for the judge to take a recess, but it was literally the impact statement that was really clearly going to get to Matthew, and that's when we had that outburst. As we wait for this 15-minute recess, we're going to play. I'm going to play for you the story. I believe it was done by our Harry Boomer. This was at the time that Ponomarenko was trying to use the insanity plea as his defense. In this story, you're going to hear the 911 phone call that he placed the day that he killed Jax Ponomarenko. We can say that now because he has pleaded guilty. He has accepted some semblance of responsibility. I'm watching the state come back out, maybe get some paperwork. They may have the defendant sign some of the paperwork outside of the courtroom. I'm not too sure we will see Ponomarenko back in the courtroom. I'm trying to think that the judge has basically already handed down the sentence, so I'm not sure how much more, and probably to keep this thing on the level, he may have to be brought back in at some point so that this can't be appealed, so that later he can't say he didn't get his constitutional rights were not explained to him fully. But In the meantime, and I want to warn you, this is a tough story to watch because you are hearing the man who killed his son call in to 911 and very matter-of-factly explain that he beat his child with a baseball bat and where the child was at that point. So again, this was from the trial, from the hearing about his mental competency, and this is from, I believe, from October of 21. Take a look.
Ponomareko was capable of understanding the nature and objectives of the legal proceedings against him.
Matthew Ponomarenko in court with his psychiatric records taking center stage. The info contained in the documents may help determine if he's mentally competent to stand trial for a very heinous crime.
I just killed my son.
What do you mean you just killed your son?
I'm hearing voices.
Also front and center, Ponomarenko tried to have his lawyer dismissed. The judge did not allow it because back in March of this year, Matthew called 911 and confessed his crime of taking the life of Jax, his 5-year-old son.
Where's your son now?
He's dead.
Dead where?
In the living room.
These are pictures of them in happier times. Ponomarenko, by all accounts, had a special bond with Jax. He had his name tattooed over his left eye and vowed in a Facebook post he would do anything he could to make Jax happy. Something went terribly wrong.
Matt?
Yeah.
When did this happen?
I'm shaking.
I understand. When did this happen?
On March 29th of this year. Ponomarenko may use the insanity defense to try and save his own life.
Insanity defense is not simply, I was suffering from mental health problems and that's why I did this. That's not sufficient.
And why did you kill him with a baseball bat?
I don't know.
Again, that was from our Harry Boomer just shortly after one of the competency hearings. And we heard at the beginning of this session here in court today, the judge did rule that Matthew Ponomarenko had withdrawn his not guilty by reason of insanity plea. In fact, the paperwork showed that he was able to understand what he did wrong and had been seen by multiple mental health professionals saying that he was competent to stand trial. So instead of going to trial to where he could have been sentenced to the death penalty, he took a plea deal that would have given him, on top of all the charges, when you have aggravated murder, kidnapping, and endangering children, you put that all together and it would be life in prison with his first chance of parole at 45. Again, a bit of a tense moment with the outburst of Ponomarenko. The judge and the attorneys for both the state and the defense are now back in the judge's chambers trying to figure out how they are going to proceed. We see some of the attorneys returning back. There is the state, and we will see if we go back on the record here as we wait for the judge to come in the room. Lost in all of this is that sweet little boy, just 5 years old, and the hell that his family has gone through over the past 2 years. It looks like we are now back on the record. Let's see if we get Ponomarenko back in the courtroom, or if the judge is going to elect to proceed with that. Looks like we are.
This shit drains the
state was moving the podium into place, so it does look like we are going to proceed with comments from the victim's family, and we will move forward with that. But the question will be if they bring Ponomarenko back in the room for those victim impact statements. Let's leave you, we'll stay right here. We're going to leave this shot and see what decision has been made by the judge as we reach towards the end of this 15-minute recess.
Not sure how long, because I don't know if I should jump ahead or not. Anybody, you got a suggestion, throw in the chat.
If you are just joining us, let's recap where we are. We have had a change of plea by Mathew Ponomareko, the Parma man who in March of 2021 used a baseball bat. He has now pleaded guilty to killing his 5-year-old son, Jax. Everything had pretty much been laid out. The agreed upon sentence, life in prison with first chance of parole at 45 years. It was just as, this Judge McGinty is kind of interesting in his procedure. He hasn't done everything exactly in order as we've seen other judges. Normally, you hear the state talk about the agreed upon changes to the charges. You get the defense to agree to those. Then you read the rights to Ponomarenko. You have him answer whether or not he's going to plead guilty or not guilty. Even that process was a little haphazard. He didn't answer the very first one. I know his defense said that he didn't, or that he did in fact say guilty. I know for a fact he didn't, and the state knew that he didn't because the state had to say, you know, Judge, respectfully, he did not verbalize that first guilty plea to aggravated murder, so he had to go through it all over again, have him answer guilty to that. And then very strangely at the end, you had the judge, you had the defense, and it shocked not only Parma, but Northeast Ohio, such a young little boy, and to have his own father call 911 and make those statements in almost a calm voice, it made national news. This, I know for a fact that this went around the nation with headlines and the cold, calculated 911 phone call. In fact, as we sit here and wait for this, and we'll make sure we don't miss a single second, let's, for those who maybe didn't see it, we're going to play our story from Harry Boomer, who covered one of the competency trials when the mental state of Ponomarenko was being debated in court. Again, this is tough to watch because it includes that cold, calculated 911 phone call from his own father. Take a look.
Ponomarenko was capable of understanding the nature and objectives of the legal proceedings against him.
Matthew Ponomarenko in court with his psychiatric records taking center stage. The info contained in the documents may help determine if he's mentally competent to stand trial for a very heinous crime.
I just killed my son.
What do you mean you just killed your son?
I'm hearing voices.
Also front and center, Ponomarenko tried to have his lawyer dismissed. The judge did not allow it because back in March of this year, Matthew called 911 and confessed his crime of taking the life of Jax, his 5-year-old son.
Where's your son now?
He's dead.
Dead where?
In the living room.
These are pictures of them in happier times. Ponomarenko, by all accounts, had a special bond with Jax. He had his name tattooed over his left eye and vowed in a Facebook post he would do anything he could to make Jax happy. Something went terribly wrong.
Matt?
Yeah.
When did this happen?
I'm shaking.
I understand. When did this happen?
On March 29th of this year. Ponomarenko may use the insanity defense to try and save his own life.
Insanity defense is not simply, I was suffering from mental health problems and that's why I did this. That's not sufficient.
And why did you kill him with a baseball bat?
I don't know.
Again, that was the story from our Harry Boomer as we see the pictures of little Jax there. I can tell you I was watching this live feed the entire time.
Yeah, thanks, Dan. Captain DeRose. I got love for you, bro, but you guys really like to commercialize the horrible shit. You really do. It's not cool. Not cool.
Could be an explanation of how this is how the next portion of this sentencing will be handled. But again, because of that just extremely violent outburst, a loud outburst of screaming and yelling by Ponomarenko, the judge ordered him out of the courtroom. The portion of victim impact statements without him in court. Now we're starting to see some of his own defense attorneys maybe reposition where they are. So perhaps the judge is going to make him come back Yeah, they are going to reposition. They're going to keep Ponomarenko, it looks like,
have to.
closest to the door,
You can't.
so that if anything like this
can't
happens
sentence
again,
them
and here he comes
without him
back into the
present.
courtroom, and they're going to sit him on the end, furthest away of any family member. And again, this may be a move by the judge, not wanting any chance for this to come back on appeal, for Ponomarenko to say, hey, I wasn't allowed in the courtroom for victim impact statements. It goes beyond my constitutional rights, so I want the whole thing thrown out. You have to understand the judge does have to be very careful, and so that this doesn't end up in something like that where maybe he wouldn't walk scot-free, but that they would have to come back and do this all over again. There were some comments made earlier about the defense attorney you see there that's smiling and laughing along with Ponomarenko. People asking if that was in poor taste, but based on the amount of court I have covered and seeing the volatility of Ponomarenko, it is clear to me that she is someone that can calm him down or at least keep him on an even keel. So I'm not sure.
All right, let's
go back into court
now. We'll proceed. I first want to note that I did read the letter from Samantha Cherney, the mother of the victim, Jax, and I want to thank her and compliment her. It was a well-written letter. It's well done as I've ever read in 50 years or so. Well done, well stated. A letter full of love and appreciation for the child. Not a word of anger to anybody, and that's amazing. Okay, so it's a lesson, just the way you wrote the letter to all of us. So thank you very much. All right. Anyone else who wants to approach?
Yes,
bring
Your
them up
Honor.
one at a time.
Jax's aunt, Jamie Lopez, would like to address the court.
Okay, great.
Good afternoon, Your Honor.
Okay. Now, if you just state your name, and this is for everybody, all you do is start out with stating your name. And take your time. Tell us under the laws of the state of Ohio, as a victim and representative of relative of the victim, how this event, death, has affected you and the loss. And anything you want to say regarding the sentence, you know what the sentence is, because I've delivered it already.
Yes, sir.
I do that purposely beforehand. It brings things emotional.
Yes, sir.
Take your time.
Okay. My name is Jamie Lopez, and
A little louder, the microphone. The one with the green lights, what I hear.
Okay.
The one in the middle. The others are
my name is Jamie Lopez, and I am the aunt of Jax and the sister of Samantha, his mother. In 2015, my sister Samantha, my sister Mercy, and I were all pregnant together. We thought it was so fun that we would all be pregnant together and our children would be close in age and grow up together. Jax was born in July, Antonio in August, and Evelyn in December. For 5 years, we would all compare stories and struggles of motherhood and lean on one another for support. However, on March 25th, 2021, the trio was no more. A son, a grandson, a brother, a nephew, and a friend was taken from us. As we have the honor and pleasure of watching Antonio and Evelyn grow, we can't help to think that all the stages of life were taken from Jax and our family, and he will be forever 5 in our hearts. I will never ever forget the horrifying phone call I received from my sister screaming, "Jax is dead." My first thought was, no, this has to be some type of mistake. A mother's scream from losing a child is a sound like no other. You can literally hear part of her soul leaving her body as those shrieks are released. That was the day that all of our nightmares began. As we learned about graphic details of how Jax was murdered, it left us with so many gut-wrenching questions. Was he scared? Was he in pain? Was he so very confused on why the man that was supposed to be his protector, supposed to be his hero, was doing this to him? We are tortured every second of every day of the thoughts of what he endured. The hardest part for many of Jax's family members is that we were not able to say goodbye due to the extent trauma that was caused to his body. Many, many professionals, such as police officers, coroners, and funeral home workers, begged our family to not ask to see him. The trauma that was created to all that saw Jax after his death is immeasurable. My sister Mercy and I knew that we had to represent his family and do hard things, and we're the only two people that had the absolute honor of being with him and being able to say goodbye. We couldn't let the last person to touch him or be with him be that of fear or anger. We spent several precious hours with him, helping make memorabilia for both our family and Matt's family. We prayed over him, we cried over him, we kissed him 1,000,000 times, and held on to him so long that by the time we left his cold body, he had turned warm. The mental and physical pain we feel is unbearable. Our hearts are broken. We think about Jax every day, multiple times a day. None of us can remember what it's like to have a solid night's sleep. We can't remember what it feels like not to grieve. We can't remember what it feels like to not feel stressed or worried or sad or anxious. We all have wounds that we will never heal from, but my sister Samantha and my mother's wounds are the deepest. It has drastically changed who they are, my mother as a wife and my sister as soon-to-be wife, as mothers and grandmothers. My mother shoulders the burden of the pain the most because she was the one that dropped him off to Matt. Losing a child changes you. It changes you so deeply and so permanently. It changes your soul, and every fiber of your existence is then molded into something that is unrecognizable. I feel like we've lived two lives, the one before Jax's death and the one we now live. The guilt we all somehow feel and the what ifs never stop. I am so very grateful that this plea was taken and that many do not have to endure the pain and graphic details that would have been presented at a trial. But there is no sentencing that would ever be enough to compensate the excruciating agony we've suffered as a consequence of this evil.
And that's about all I'll give them.
There is one photo that Jeanette is just going to bring to you. And it just represents the last moment and the love between me and my sister and Jax.
Mrs. Cherney, Janice Cherney, the maternal grandmother, would like to address the court.
Thank you. Can you identify yourself, Mrs. Frank?
My name is Janice Cherney. I am the grandmother of Jax.
Thank you.
My daughter is Samantha. Please bear with me.
Take your time. Let's breathe a second, relax.
Judge,
Let me ask you a couple questions here in the application. See if that works.
well,
Tell me about you. Where'd you grow up?
I grew up in Parma. Yeah,
Spent your whole life in Parma?
pretty much so. Yeah. I live there now. Raised 5 beautiful children. Have 11 grandchildren. 1 in heaven, though.
How many grandchildren do you
11. And I'm about to become a great-grandmother for the first time this January. Judge, while I'm standing here in front of you before I start reading, there is one person I would like to address in this room. And that was Jax's therapist, Jackie. She was an angel in disguise. She taught Jax so much. She was the most wonderful person and loved Jax as much as we did. And if I could say, she is sitting right there. She just had a 1 year, her daughter just turned 1. Okay. Today I stand in front of you to tell you a little bit about my autistic grandson, Jax. He was such full of life. The obstacles he overcame, he made me see the world in a different way. To reading sight words, singing every song you could think, to saying, I love you, to saying his brother's name, Dominic, for the first time. Taking my hand, placing it on the wall, and singing Itsy Bitsy Spider. His little hand going up my back while I'm washing dishes, and him giggling. Every time I would put him in a car seat, he'd start giggling because he knew when I put him in there, Grandma's gonna get you. And I'd start tickling him. Dancing and singing in the living room with his mom and me and his brother. Chasing his brother around the house and laughing. Him catching the water in his mouth when his grandfather would be watering the lawn. Watching him and his brother cuddling with his mom, my daughter Samantha, and the look of love in his eyes. Matt, you took away from my daughter, his brother, me, and my family. I'm sorry, Judge. Holidays, birthdays, watching him grow up into the man he would have been. Jax's handprints are on my mirror. His tablet is in my window at the top of my steps. They will remain there until the day I die. My life will never be the same. Sleepless nights, crying to certain songs, leaving work because the child looked like Jax, going through the grocery store and having to leave because I would always get him a donut when he was with me. Judge, I would like to ask Matt, to Matt, only him and God knows what had happened. I would like to ask him, why did you stand there talking to me that day when I dropped Jax off? I could tell you every single conversation that we had. Why did you text Jackie, his therapist that was coming there an hour later, and telling her not to bother coming over? Why did you tell your sister after that phone call you needed to go because Jackie was coming over? Why did you go to the garage to get a bat? all I could think of is that poor boy thinking, Daddy, why are you hurting me? My first vision is him walking up the driveway with his father and me saying, I love you, buddy. My last vision is running towards the house and the detective stopping me and me saying, where is my grandson Jax? And him telling me he is gone. My last question would be to Matt. Why did you kill him and not yourself?
And she did just have a photo that she wanted you to see as well.
There's another one in Jeanette. Jeanette, there's another one in there, a small one. That's here with his brother.
He was truly blessed.
His brother saved me on 4th of July. Grandma Jax would love this. His brother saves me. How old is Jax? Grandma, I could have been teaching him how to play baseball. Your Honor, this is an agreed sentence. And as you know, the purposes and principles of sentencing are to punish the offender and to protect the public. And this case has been completely devastating to our community, to the Parma community, to the law enforcement of the Parma community that were the first responders that responded to the house. There is really not much to say, only that adults are responsible for their actions, and actions have consequences, and that Mr. Ponomarenko will suffer those consequences by the sentence that he has received for taking the life of his 5-year-old autistic child. As part of the record, Your Honor, I would like, and for purposes of any appeal, the state of Ohio has put in a sealed envelope the autopsy report and a report that was made by the Cuyahoga County Medical Examiner's Office, the Trace Evidence Department, that has documented every single picture of the house and the damage that was caused to this child. So I would ask respectfully that you make that part of our record. Thank you.
All right, we previously discussed this, the parties have agreed that those records, all the records of the autopsy and the examination by the coroner's office and the related graphic police photos necessary for the investigation will be kept under seal, but part of the record of the file. Okay. Accept them without objection and put them in. Anything else from the state?
No, Your Honor, but after we've concluded, we'd ask that you reimpose the sentence.
I will.
Okay.
We're gonna. I like to let everybody know what the sentence is going to be, an agreed-on sentence, so we don't have impassioned arguments as to from the parties' representatives as to what the sentence should be, because they already it's going to be what it is agreed to. So there's no use to request their opinion on what it should be. So I try to avoid that part. It makes for a calmer phase of the trial.
Thank you.
For the sentencing. All right, now for the defense, their opportunity to be heard. They can feel free to call anyone you wish to make a statement on behalf of the defendant or the defense of the issues involved. And of course, the defendant finally himself will have the chance to make a statement should he so wish.
Thank you, Your Honor. We would like to make some brief comments.
Sure.
On behalf of Mr. Ponomarenko and his family as well. But before doing so, we do have two family members who wrote letters for court's indulgence.
Sure. I haven't seen them yet, but I'm sure we will read them.
Approach and read the letters on the record.
Okay, that's good. You want me to read them on the record? Do you want to read them on the record?
Your Honor, if that's okay, I would read them. And
Go ahead.
Okay, standing right here, I think everybody.
Wherever you want to be, that's fine.
Thank you, Your Honor.
Thank you, Your Honor. We did receive two letters. The first one is from Matt's sister, Angela. She wanted to be here today, but she was worried that she would be too emotional, so she did ask that we read this, her letter on the record. I would first like to say thank you all to our family, friends, and legal team. Without the amazing and consistent support you all have given us, I don't think we would still be standing through this living nightmare. I often describe the complex pain and loss as hell on earth, because that is exactly what our tragedy feels like. Thank you for finally giving us a chance to be heard, because we have been treated like we were not victims as well, and that is so far from the truth. I pray for every single person affected by this tragedy. Every single day we live with the pain of losing Jax. Every single day as I drop my son off at school, I am reminded that Jax should be walking in right behind him. Autism is a journey full of joys, challenges, and a roller coaster of emotions. It has always made me sad that our boys were not able to attend school with their siblings. So having Jax and his cousin being together at their autism academy meant everything to me. They had each other. Dear Jax, I will never forget the first time that I held you after you were born. It was instant auntie love, and I thank you for making me an aunt. I took that role very serious and just as important as being a mom. It was such a blessing and a joy to watch you growing into such a sweet, amazing, funny, and loving little boy. Your smile, your singing, your happiness melted everyone's heart. I took such pride in helping you through your autism journey and assisting with the process of getting you the very best support to watch you thrive and grow. It was an honor. I miss you running into my backyard to play every week. You sure loved doing an intro lap around the entire house before heading inside to play and dump all the toy bins. You loved taking home a toy too, and I sure loved those hangouts. I miss you and your cousin throwing coins down your daddy's vents in his car. We always laughed at the double trouble. I miss giving you haircuts, even though you sure didn't like them, so I made sure to always give you a treat right after. I miss your singing, your smile, your hugs, hearing your tablet play the same parts of a video over and over and over again, and your joyful presence. You sure knew how to put a smile on everyone's face. I miss cousin sleepovers. You would always pull the kids' hands back in the house when we tried to leave, because you just loved being together. I am thankful for all the time that we spent together, and I am also heartbroken that we don't get to see you grow up. It's just not fair. None of it. I'm so sorry that this happened to you. Please know that we always had your best interest at heart. We poured our hearts into making sure you had the best life possible. Jax, I hope you know your daddy would never hurt you intentionally, and he and your family love you very, very, very much. We miss you. Until we meet again, buddy, Auntie Ange loves you forever and always. I miss you every single day. I hope you're dancing on the waves, singing your heart out with Jesus and other angel babies. I just know it's the wheels on the bus that you are singing. She then continues, Dear Matt, thank you for being the best brother that any sister could ask for. You are my best friend. We have always had a bond like no other, and I am so thankful that no one can ever take that away from us. I am sorry that you have always dealt with daily silent battles that you went through. No one should have to live trapped inside of a body that is fighting against their own mind. Invisible disabilities and diagnoses are so misunderstood and disregarded. Watching you become a proud, nurturing, patient, loving, protective, and invested daddy made me so proud and happy for you. You guys were always out on adventures, whether it be the park, the splash pad, Chuck E. Cheese, or wherever it was that Jax wanted to go. You just wanted your son to be happy, and that's all you ever cared about. It was pure love and a deep one. You and Jax had the strongest bond and were the best of friends. We know he gave you the strength to want to live a healthy and happy life. All you ever wanted was to feel better. Your goal in life was not about money or materialistic things. It was to come out on top of your struggles and be the best daddy and the best person you could be. That is something everyone deserves. You did not ask for much. Your little boy gave you so much strength, love, and motivation. I'm proud of you for fighting so hard. I'm sorry that your cries for help were disregarded. I'm so sorry and sick to my stomach that several medical professionals made poor, reckless, fatal choices right before this happened. It cost Jax's life and Matt's as well. While those professionals go home every night to their families, our families are all forever changed for the worst. It's easy to blame Matt for this horrific loss because he's physically responsible for taking Jax away from this earth too soon in the worst way possible. But it definitely was not his heart, his mind, or in his control. That I know for a fact in my heart. Realizing before it was too late, Matt never should have been responsible for Jax that day, and we all have to live with that regret and guilt. The guilt and the pain that Matt has to live with every day is enough punishment in itself. Because at the end of the day, our society and our legal system think that the right answer is to put the sole blame on the individual instead of recognizing the huge problem of our mental health system. It is a broken medical and justice system. Matt willingly fought for addiction and mental health support for years. He advocated loudly for himself the best he could, and we were right next to him through it all. We just wanted to see him win. All of the people that really know him know that he is a kind, loving, funny, emotional, and just a really good man. He's a big teddy bear. He's often referred to that as.
Should have removed himself.
He has asked for extended stays at mental health facilities multiple times just before that awful life-shattering day. I can attest to this because I was actively calling facilities, but his insurance just wasn't accepted, or they wouldn't cover a stay of more than a few days or a week at most. No one wants to willingly go and stay at a psychiatric ward if they knew that they didn't need to. But Matt knew he needed help and support, and he just wanted to feel okay. And what makes me sick is that through all of this, he still won't get the help that he's been begging for. Both he and Jax deserve someone to listen and help. While many people may find this ending the closure that they need, our family and friends find it heartbreaking without true justice. Just as Matt would not want to take Jax away from this earth, and Jax would not want this for his dad, because he knows how much his dad loved him. If you don't understand how this could happen, or you say that mental health isn't an excuse, you are right. It is not an excuse, it is the reason. And until we make a change within our very broken systems, many more families, unfortunately, are going to continue to suffer just as we have. Consider yourself blessed if you don't understand mental health battles, because that means you or a loved one don't live with it. At the end of the day, Jax is gone, and so is Matt. The grief and pain of losing them both is something that I will never be able to put into words other than its slow daily torture. I will continue to advocate for autism, for other disabilities, and for mental health for Jax and Matt, because they deserve that, and so do others battling the demons in their head that nobody else knows about. I will be part of the change for them, because my love for them keeps the fire inside of me, needed to keep fighting for change within our systems, as both of these systems have failed both Jax and Matt. While some people don't understand how this could happen, feel lucky that you do not. The people who actually know our family know the actual truth and not a theory about why this hell happened. God and our family have already forgiven Matt for his actions because we know that he was not in his control on that horrible and horrific day. We also know that that horrible day does not define who Matt was as a daddy. Everyone who knew their relationship knows that. You do not strip somebody cold turkey off of several antipsychotic meds and add new ones on top of that and send warning them of the possible side effects or the experiences that some may endure. That is just downright ignorant, dangerous, and fatal from trained medical professionals. Auditory and visual hallucinations are very real. Psychoses are so very real. All of this is heavily documented, but apparently none of that mattered. And that is the most heartbreaking, maddening, and unsettling part as we gather here today. No true justice and no true peace. I am sorry, Jax and Matt, we fought a good fight. I recently watched a video of a woman about to pass into heaven and how she was staring up into the sky without blinking and explaining how beautiful heaven was. She was waiting for the gates to open for her and was mesmerized by how pretty heaven was and how beautiful the singing was. I just know that Jax band was part of that beautiful singing that she heard. For me, that was the peace I needed, to know that one day we will all be reunited in perfect health and healing. No more pain, no more struggle, and no more disappointment. Broken things happen in this broken world and system. And one day, we will all be set free from it all and be together again. Today and moving forward, I pray that people find it in their hearts to stay focused on the amazing boy Jax was and to remember all of the good memories, because that defines him more than that awful day. Please just let him rest in heavenly peace. Jax and Matt, I love you both so much. I'm so very sorry. This wasn't how it was supposed to be, not for how hard we fought. Forever and always, I'll keep fighting for you until my last breath. Love, Jax' auntie and Matt's sister.
All right, thank you. Is there another letter?
Yes, there is, Your Honor. We also have a letter from Matt's mother, Karen, who is here in the courtroom, but did not wish to address the court personally, so she also wrote a letter.
Okay, we'll hear it. Go ahead, please.
On behalf of Matt's family, we want to thank all of those in our personal lives and all those in the community who have supported us through this tragic ordeal, which occurred on March 25th of 2021, and forever changed our lives. We also want to thank our legal team that worked endless hours in support of Matt's defense. Without this support and your compassion, our family would not have survived this trauma. Sadly, on March 25th, our families lost our beloved Jax at the early age of 5 from trauma caused by the hands of his father. Our families, as well as those who loved and cared for Jax, have been greatly affected by this tragedy, and I consider all of us, including Matt, to be victims of this horrific nightmare. On that day, 3 lives were taken from us. The life of our beautiful Jax, the loss of Matt to our family, and Matt's loss of his life to an unimaginable life in prison, where daily his head will not allow him to escape this devastation. Despite what might be said in this courtroom or shown on the news, I assure you this violent act was not a premeditated act. This tragedy is the result of mental health crisis that followed consecutive weeks of failed treatment at various psychiatric facilities and treatment centers in both Lorain and Cuyahoga County. The news media will again portray Matthew as a monster, as done previously, showing the view which they would like people to believe. Once again, we will hear and read hateful comments placed on social media against Matt and our families. I assure you, the people who speak these remarks do not know Matt at all. Matt is a beautiful person, and much more than his addiction and his bipolar disorder. I would say most people would describe Matt as a giant teddy bear, who is funny, loving, handsome, and dedicated to his family. Matt is a son, a grandson, a brother, an uncle, a loving father, and a friend to many, and Jax was the love of his life. Matt especially loved the family that he and Sam created. Matt loved Samantha, Dominic, and Jax with all his heart, and he wanted nothing more than to be the best dad that he could be and to provide for and protect his family. Matt loved being a dad. From the minute Jax was born, wherever Matt was, you could find Jax right next to him. Jax could do nothing wrong in Matt's eyes, and he was Matt's best friend. Jax was completely impossible not to love. He was a special boy who was happy, silly, smart, messy, and alone. He could melt your heart with a tilt of his head and a smile. Jax made everyone who knew him a better human being. We were so blessed to have him in our lives, if even for a short time, and we miss him every day so much. Jax was also the one that brought our families together. However, on March 25th, we lost the joy of our lives. It was the day that changed our worlds, broke our hearts, and I don't think any of us will ever be the same. There is not a day that goes by that I wish we had not placed the responsibility on Matt to watch Jax. Not a day goes by that I wish I had stayed home from work that day, or that someone else could have watched Jax, just long enough for us to get back home. There is not a day that I forgive myself for not realizing how badly Matt was struggling on that day, and the days prior. While Matt was more quiet and subdued, I did not know the voices he was hearing and who was controlling his thoughts. This I will have to live with. Jax was Matt's greatest joy in life. He was the greatest joy to all of us, and not one of us would ever want for him to be harmed. We only wanted to love and protect him, as did Matt. To this day, I believe, as others do, that Matt's thoughts were being controlled by someone other than himself, and he was in a psychosis. Matt would never hurt Jax. He loved him more than anyone. The only life Matt at times wanted to lose was his own, due to his demons. The reality of this tragedy has forever crushed our souls, and not just ours, but Matt's. I've told Matt numerous times that he should forgive himself and believe that he has, as I did, and know that Jax did. Jax knew how much his daddy loved him. Jax was the one person Matt wanted to get better for, to live for, and he wanted to be there for. It saddens me that Matt will forever live knowing it was his hands that took Jax's life away. And I pray that he realizes it was not his heart or mind that was responsible for this. The sadness all of us are experiencing will never go away. It may lessen with time, but it has not as of yet. While I wish this day could be reversed, I also wish I had been given a chance to hug both Jax and Matt one last time. My heart breaks for Sam, Dominic, her family, my family, and everyone who knew and loved Jax. My heart also breaks for my family and friends that love Matt as well and always will. In conclusion, this tragedy has affected all of us, physically and emotionally. At times it has incapacitated us. Not only do I pray for all of us that we may find some peace in time, I also pray for all of those suffering from mental health issues or that are affected by them. The stigma against those with mental health issues is real. Our county is sadly so behind in providing funding for state-of-the-art treatment, for providing accessible and suitable facilities needed to improve outcomes for all, despite race and economical differences. While our country is aware of these needed changes, the change is too slow, and the mental health populations continue to be greatly neglected. Additionally, the laws in the state of Ohio pertaining to mental health treatment and the prosecution of those with mental illness are heartless. Until these changes are made, many more lives will regrettably be taken, and the incarceration rates of those with mental health issues will continue to rise. Until then, the neglect of this population will continue. In the end, what I realize is that it is not one family or another that are victims of this tragedy. We are all victims of a broken health system that resulted in the loss of both Jax and Matt, and feel that no justice has been served or will be served for either Jax or Matt. Although our hearts are heavy, I rest at night knowing that one day we will all be together in the kingdom come. Until that time, I will fight for change in our country by supporting NAMI of Greater Cleveland, which provides numerous mental health services for individuals and families, and I will never stop fighting for the rights of those with mental health illnesses. Karen Ponomareko.
Thank you. That too was an excellent letter. I appreciate all the thought that went into it and the considerations and generous spirit. It's interesting that you have both great letters from the mother of the victim and the mother of the defendant in the same trial. Very unusual, very striking. So thank you both for those letters.
Your Honor, the only thing that I would add, may it please the court.
And no animosity in either one that I could detect. They're very generous spirits. Go ahead.
Nothing that I could say would make this tragic situation any less horrific for the families. When I say the families, I mean both sides of the family. Our heart goes out to them, to everyone that's in this courtroom that has any relationship whatsoever with Jax and Matt. Your Honor, we simply ask that you adopt the agreed recommendation. I believe it's crystal clear that Matthew is suffering from sickness that unfortunately the mental health system he's been in and out of for quite some time. The records that the court has, I will not labor over them, but I believe it's clear that he was suffering from mental health. Your Honor, our hope is that this court will impose a recommended sentence that we all work hard to achieve and to spare the families from going through a trial of this magnitude where everyone loved the parties involved in this case. So with that said, Your Honor, there's nothing more that I can add but ask that you humbly and respectfully adopt the sentence as agreed upon by the parties. And our hearts go out to the Ponomarenko as well as Samantha and her family, the Shirley family, for this tragic incident that I know that they would all have to live forever with, as well as our client who has to wrestle and live with this daily. And we've seen his ups and downs over the last 2.5 years, just about. And we know that how much he loved and cared for his son. We respectfully ask this court to take all matters considered and impose a sentence that we agree. Thank you.
All right, thank you, Mr. Kine. Appreciate it. Now, the defendant himself has the opportunity, lastly, to make a statement to the court, into the record, should he wish to do so.
I'd like to say I'm sorry.
That's all, Your Honor. Thank you.
All right, thank you. Thank you for all the statements of all. The court now is going to go formally through the sentencing. I informed the parties that I'm accepting the plea, accepting the agreed on plea, well considered, well negotiated plea that's commensurate with the evidence and the facts in the case and the law. Keeping in mind now that the sentences the court gives must be comply and consistent with the purposes and principles of Ohio law, which is codified under Chapter 29, and particularly 2929. And the overriding purposes of sentencing is to protect the public and to punish the offender while preventing future crime by the offender and others who witness and see this crime and the harm it has caused and the punishment that must be inflicted, however harsh it is upon the defendant. It's earned and well-deserved. This is a case where incapacitation, deterrence is needed, rehabilitation is possible and hoped for, and restitution, unfortunately, is impossible. It's just not a crime where restitution can be achieved in any meaningful manner, except that the defendant do his best to rebuild. It boils down to rehabilitating yourself when you get to prison. The tools are there to grab and use and helpful, but only the defendant can grasp them if he's capable of doing so, and listening and thinking it through and trying to become another person. And while paying for the harm he has caused his innocent child and the family from both sides, and the community for the loss of such an asset to the community, such a lovely kid, a child gone and needlessly. So the sentence that has been agreed to and the court's going to impose is commensurate and not demeaning to the seriousness of his conduct and the impact on the victim. It is consistent with sentences for similar crimes by similar offenders. In my experience, this agreed sentence is a logical, well-conducted negotiation that has achieved the ultimate outcome. This, as a capital case, had although worthy of thorough investigation it received, had no practical chance of being achieved in the long run. So that the sentence and agreed to is logical and predictive of the ultimate outcome anyhow. Both sides have worked thoroughly, professionally, and the court appreciates it, salutes it. Starting with the Parma Police Department, this is an extremely difficult case for a police department to work on. It's, although I'm sure the police didn't know the individuals, it tears the individual police departments and individual officers hard too. It has a great effect on them, not just now, but, like the family 20 years from now and 40 years from now, they're affected by these dramatic, awful events. But most importantly, you know, we talk about the victims' families and friends and the community harm, but the biggest victim in all these cases, the real victim is the child, is the person who was killed. Their life ended, their life is cheated, their life is eliminated, their chance of happiness in the future, and family, and future pleasures of life and experiences are denied, they're stolen. And that's the greatest harm, that's the greatest victim. It's a victim we don't hear from in these cases. And so this conduct, the court reviews under 2929 the seriousness of the conduct. So it was exasperated, the events, by this child's vulnerability. This child had no way of protecting himself from an adult man or a baseball bat. The victim had his own issues, and he was totally dependent on the care and help of those entrusted to give it. The offender violated that trust. He violated that obligation to the child. He had the wherewithal, these records show, mentally, to control himself and not do such an abrupt action that was so terrible. The court doesn't doubt his remorse today at this point, the remorse he's expressed throughout the proceeding and through the various professionals he's dealt with, or his defense team. But he still had the ultimate violation here and deserves this life imprisonment to which he's being sentenced. There is no excuse here that would alleviate his guilt to the crime or make his conduct less seriousness. Based on his action here, the court must and the community must consider recidivism and the chances of doing so if he was to be put in the community again, and must be so hesitant to do so, and that based on this violent, horrible, horrific action he committed, and that must be now the responsibility of the Ohio Department of Rehabilitation and Correction in the future when they decide if there should be a release date ever. That is not to say that the defendant shouldn't work towards one and shouldn't try to improve himself as much as possible so that he is able to control himself and recognize his issues in the future. The court hopes that these families that are left, the aftermath here, are healed and can move on with life, or else they too become a victim. If they don't heal, if they don't get past this, they too are the victims of this horrific act. And I don't think that child or anybody wants that. Somehow, both sides of this family have to get through this, the sorrow they're going through and the remorse they're going through. Look at, like, the letter I received from the mother. Look at the bright side, the privilege of knowing the child, and the bright spirit he surely was from the description here, and be thankful for that and move on and try to move on in a positive way and not let this destroy your future in your life, including the defendant. He has taken the first step, which is responsibility for this crime and willingness to accept the punishment he so richly deserves in this case, and to move forward with his life. So the court now will formally pass a sentence in count 1, life imprisonment with parole eligibility after serving 30 years, full years of imprisonment. Count 2, an indefinite prison term with a minimum prison term of 8 years. Count 3, an indefinite prison term with a minimum prison term of 7 years. Counts 2 and 3 aggregate to a sentence of 15 to 19 years with the Reagan-Tokes aspect. Each count is to be served consecutively for an aggregate prison sentence of life in prison with parole eligibility after 45 years. And should the defendant come up for parole in 2066 or thereabout, that doesn't mean he's going to get parole. It's possible, but and only possible, is all I can say, is that the parole board will look at the defendant's behavior and progress he has made, if any, and hopefully he will, while in prison 43 years from now. He is to be given credit, as we noted earlier, for 960 days. It's exactly 32 months off the sentence already served for time since the date of his arrest on March 25th, 2021. These consecutive sentences that the court has imposed are necessary to protect the public from future crime by the defendant, to protect others in the community, and these consecutive sentences the court hereby finds are not disproportionate to the seriousness of his conduct and to the danger he proved he can pose and has posed to the public by these actions. There was a course of conduct that caused harm that was so great that no single prison term could adequately reflect the seriousness of his conduct and the danger and threat he posed to the safety of the community. His sentence may begin. If there's nothing else, the court is adjourned. Okay, thank you. Yes?
Just for the record, I would just ask that counter objection to the Reagan toast.
You pardon one?
Reagan toast, imposition of the Reagan toast, indefinite.
Okay, I think we explained that. Do you want that re-explained?
Your Honor, I believe he just said he would like our objection noted.
Oh, your objection, okay.
Yes.
That's fine. I understand your objection and overrule the objection, but you prefer, you've preserved it. All right, of course, anything from the state?
Yeah, Your Honor, there's an appellate advisement too. If we could just...
Okay, we'll give appellate advisement there. It's a limited appellate advisement. That the defendant should be advised that from this point he has 30 days to appeal the case or sentence here, although it was an agreed sentence. It was agreed upon by him and his counsel. He has 30 days to give notice to the Court of Appeals 8th District, which is the superior court to this, of such appeal, notify his attorneys or notify that court in writing of such an appeal. Is that sufficient, or do we want any extension to that?
That's fine, Your Honor. And then I know the court earlier mentioned post-release control, but if the court wanted to formally impose
All right.
post-release control.
Well, it's automatic, post-release control, 5 years, and otherwise known as parole. The other is post-release control in each count, but they're redundant in lesser than the 5 years, so it boils down to a 5-year post-release control. Should he violate the post-release control, as he was advised earlier, he could go back to prison again and serve up to half the time on that case. He also has a Reagan-Tokes incentive to perform well and behave well in prison, or he could have an additional, before he's placed or considered for parole, 4 more years. He's reminded that just because he has parole eligibility doesn't mean he will get parole, and his behavior in prison would affect whether he's even given a hearing or not. So his best behavior would be good advice. It would be good action to shoot for, good conduct. Anything else before we close this case? Anything from the state? Mr. Tide? All right, court's adjourned. Thank you for everyone. Thank both families for their patience in going through this very difficult time. Thank you.
Dan DeRose with 19 News. As this comes
What
to
down,
a
Dan?
close.
Holy shit. Excuse me 1 minute. Yeah. Mental health issues or not, you can't, you don't get to do that. You gotta take care of your shit, man. This was a real tough one. Thank you, Tommy. I really, really appreciate you, man, hanging in here with me. This has just been. I'm not even making a short on this one. This one's just too much, man. And I feel horrible for both families. I really do. But at the same time, I don't know, bro. I don't know. I can't wrap my head around that. I can't call this a you done fucked up, whatever. You know, I don't even care about the cursing right now. Because honestly, that's how I feel. That's how I feel. I feel horrible for both of the families. I'm enraged about him, but I feel bad for him too, in the same sense. Because you can dead see that he really didn't. That wasn't. But you can't. You don't get to do that when you got a kid. You just don't get to go and be all messed up, man. Yeah, it is, Tommy. It's a horrible situation. Effed up on so many levels. On so many levels. If he was going through it like that, right? Why would you even give it the opportunity to have him alone with the children? Child. I don't know. I don't have the answers. I said I was going to make them fit. I'm not doing nothing. I'm just leaving this one go. I can't even do a short on this one. It's that bad. There's... Nah, I draw lines, man. This is one of them ones where, nah. It ain't worth it. It just ain't worth it. Somebody will do a courtroom brawl or craziness, whatever. Nah, man. It's a baby involved. Autistic baby at that. 5 years old. Beat down. Like dudes you used to get beat down in the street in the 80s and 90s. Can't happen. We gotta do something. We gotta do something better as a society. Like I said, I'm not here to save the world. I can't hardly save myself, man. At the same time, man, we just gotta do better as people. See somebody in crisis, get on that, money. Get on that. Be a part of somebody's life, man. Maybe this won't happen. But thank you all. I really do appreciate you coming in. And to the people who view this later, I'm truly sorry because this is one case that is just insane and it is gut-wrenching. Not something that I'm proud of. Not something that I want to continue to do. But Tommy, you said it. It has to be talked about. It has to be out there. We need to have conversations about serious things that go on in life. It just needs to happen. And I'm not trying to dirt his family up by any means. At all. At all. God bless them. And God bless all of you. God bless all the best. I'm getting out of here, man. I can't deal with this right now. Salute. Take care of yourself. Take care of each other. South Philly hillbilly. I don't know. I'm sick. I'm silly. Thanks again. I really mean that from the bottom of my heart. Thank you. And I'll see you soon. Really will, man. I hope to actually one day and meet you in person because, yeah, you the man. I appreciate you. Take care of yourself, Tommy. Please do. Need you around here.